there's a slight confusion with on my part when it comes to immunity. Now, sometimes when I hear it being described, it's like, hey, your testimony can't be used against you. But what about the crimes you admit to? Like, for example, say while I'm on the stand, I said, and nobody knew this, yeah, little Ronnie, yeah, I killed him. I did kill him. And I admit to it. Now they be like, well, we can't use the testimony, but we could go investigate it knowing that he kind of did tell us he killed him. We just need to find other things other than the testimony to corroborate him. Am I void of all crimes I actually discuss? Or is only my testimony to those crimes that's void?
You know somebody who's probably asking themselves that question? Kenneth Copeland. Woody. You know what the answer to that question is?
What?
You are absolutely on the hook for any crimes you committed that they can prove without using your testimony.
Really?
You do not, when you get in that Georgia statute.
That's like a slimy thing though. Like, you're going to compel me to testify and then you're going to try to investigate me?
Well, you gotta, I mean, there's a lot here. So you gotta unpack the whole thing and then you can kind of see how this shit fucking really can be oppressive. So that's called use immunity, that what you say won't be used against you. Totally different from maybe what people would refer to as just immunity or absolute immunity, which means that you'll never be charged with any crimes, right? That's not what he got. He got use immunity. And one of the questions that I think will be asked on appeal and part of these mistrial motions that you're going to see is that the judge conflated the two things. The judge is on the stand talking to Woody, and he's like, yo, yeah, look, I'm going to jail you. Or you can testify, and you should testify because you have immunity. And it's like, you heard that from the judge, so you might be thinking, oh, I'm good. I could say stuff, I'll never be charged with that crime. That's not true. You'll never be charged based on what you said. You could absolutely be charged for that crime still. That's my opinion. That's my reading of the statute. I've discussed it with many criminal defense attorneys. This is a bedrock principle. That it's different when you get use immunity versus just full-on immunity.
By the way, and I want to table this, so remind me this later, Leaf. That was a thing too for the Meg case, right? Because the whole Kelsey, we all assumed there was some immunity there, but people felt like she was guarded because if she admitted to possessing the gun, that would be something else that they could investigate even without her. Anyway.
That's absolutely right.
All right. So let's stay on Woody. So the night before, his lawyer says, I'm not testifying. He's not
testifying.
Wow.
So he says he's not going to testify. They come in. The judge gets Woody up there, gets the lawyer up there.
Was he arrested this whole time? I was wondering, I've never seen this motherfucker before. Like, he just disappeared. I thought he was in witness protection. How do you hide a witness this good? Everybody's roasted him online. They were roasting him for months. We had the video of him in an interrogation room. We never seen him. Where was he at?
Bro, Woody got 11 convictions. He's been in prison most of his life. However, for the past 2 years, he's been out, even though he was convicted, pled to possession of a weapon by a felon. I think that was in 23. He was convicted after he pled to possession of an illegal substance with intent to distribute. That was in 22. And that was his conviction number 10 and 11. He was out on the street free as a bird the day that he was called on to testify. So there is a lot of reason to believe that Woody has been saying God knows what to whoever in order to get out of his multiple convictions, which led to pleas, which then leads to sentencing where you need to ask for leniency. So let's go back to Thursday night. They say that Friday morning they show up into courtroom. Friday morning, the judge brings everybody up in there. They get Woody's lawyer, Melnick, on the podium, and Melnick says he's not testifying. The judge says, all right, well, let me get him up here. Let me hear it from him. And when the judge gets Woody on the stand to hear it from him, I encourage everybody to go watch Day 87 when Woody is being asked by the judge. You'll see it on the live stream. And the judge makes this conflation between use immunity and immunity. And the judge is trying to, the judge is supposed to be impartial. But if you watch the judge talk to Woody, it sure as hell seems like the judge has an idea of what the best thing for Woody is, that the best thing for Woody would be for him to testify. So anyway, the judge starts talking to Woody and he's like, yo, if you don't testify, I'm going to hold you in contempt. That means I might have to jail you. And, if you do testify, you got immunity and I wouldn't jail you. Now, the judge makes no explanation of the distinction between use immunity and absolute immunity.
Which, by the way, if anyone's ever been to even traffic court, anytime you, like, when the judge is talking to you and you're usually a little scared or whatever the case is, and, if you try to ask certain questions, they're quickly to assert, hey, listen, I am not here to give you advice. You need an attorney for that. You shouldn't be looking to me on what you should do because I'm not operating in the betterment of what's good for you. I'm here for the betterment in what's good for the courts of justice. So I do get you on that.
So the judge and Woody are going back and forth on this conversation. Melnick is up there on the podium. Steele's trying to interject, and the judge just keeps going with Woody. And Woody's like, nah, I'm not going to testify. And then the judge is like, wait, but let's make sure you understood what I said. And Woody's like, nah, I'm not going to testify. And then the judge goes and takes a third run at him.
Yeah.
And on the third one, the guy's like, okay, I'll say whatever you want me to say. And the judge is like, everybody's like, well, what does that mean?
What?
And they're like, well, are you going to testify? And he's like, yes. And they're like, all right, cool. So they bring the jury out. Now they bring the jury out. Prosecutor starts asking questions. Like the third question, what does the witness do? I plead the fifth. And that was the first moment that the YSL trial completely went off the rails. Now, we believe it's gone off the rails, but you ask a defense attorney, ask your uncle who, does cases, whatever. That shit went off the rails on that moment because here's why. For months, the jury has heard about Kenneth Copeland, Woody, Kenneth Copeland,
Yep.
Woody, murder, robbery, murder. Kenneth Copeland, Woody just took the stand. And what's the first thing that motherfucker says? I plead the fifth. And there's a bedrock principle in criminal law. If you're calling a witness to the stand as the prosecution, and you know the witness is going to plead the fifth, you cannot call him because it's going to make the defense look guilty as fuck. I'll give you an example. Me and you go commit a crime. You're charged as the accessory. I'm the main defendant. I'm on trial. You got a deal or some shit. Whatever you got, you're not on that trial. You're a witness. For weeks, the jury has been hearing, Mo robbed the bank, Ack was in the car, Ack drove him home, Ack threw out the gloves, ba, ba, ba. All right. The jury hears about how Ack has been charged with an accessory, Ack was in the car. All right. Now Ack gets on the stand. Mr. Academics, do you know Mr. Gangat? I plead the fifth. How does that make me look?
Yeah, you do look kind of crazy.
How does that make me look?
You look guilty.
Now, if you knew as the prosecutor that Ack was going to get on the stand and plead the fifth, you have an obligation to not put him on the stand. And if you go back, I encourage everybody to watch Day 87 when the judge is going back and forth with Copeland. There was good reason to believe that Woody was about to take the fifth on the stand and the judge should not have put him on there. Further, after this happens, right, Woody says, I take the fifth. Judge, everybody realizes, fuck, that should not have happened in front of the jury. Jury is sent outside, and all the lawyers start standing up one after another on the defense. Mistrial, mistrial, mistrial. They knew. And the judge is sitting there going, oh, well, I'm not sure that they knew. And it's like, bro, did you just see the confusing fucking set of conversations that you had with Woody where multiple times he told you he's taken the fifth until you kept asking him questions to the point that he got so confused that he just said, I'll say whatever the hell he wanted me to tell it, I'll tell it. Woody, in his mind, when he said, I'll tell it whatever they want me to tell, he was going to tell I'm taking the fifth. Woody's not like the sharpest tool in the shed.
Yeah.
You know what I'm saying? Like, you asked him the same shit 3 times. The third time, you're going to say, I'm going to do what y'all want me to do.
Mm-hmm.
And I think, if you watch that, I think a fair observer would say when he said that, what he understood him to be saying, what he assumed other people were understanding, is that if y'all put me on the stand, I'm going to say on the stand I take the fifth.
Yeah.
So these lawyers all go up there and they're going nuts, and then and Steele and Shaw, they're all going nuts. They're all like, yo, forget about you, Judge. The prosecutor knew that he was going to take the fifth because after you did all that with him 3 times, everybody went outside for a break. We're going to come back with the jury. While they were on break, a bunch of people heard Woody on the phone telling people, I'm taking the fifth, I'm taking the fifth.
Let me ask you this question, because I think people are going to be wondering this. So what's the difference between that and like Tekashi 6ix9ine situation? Because 6ix9ine have done the same. Be like, hey, I'm pleading the fifth. Because I think what we were kind of seeing here is like, I think that what the judge kept saying, which that's what we believe with the 6ix9ine thing, is like, obviously 6ix9ine is a federal thing, and he had it was a 5K1 letter, but he had immunity on whatever he said before in whatever proffer session, and he's like, hey, you got to repeat it here, right? So I thought that at least with the Woody situation with the prosecutors, they had something to compel him to say, hey, remember, we're dismissing some charges, or not going to prosecute you in whatever, and give you immunity, which you told us, which they had to talk before. This shit felt like crazy. Like, have they never talked to this guy before?
That's a great point, Ak. And that begs the question that if there is no formal 5K or something like that they would have in a Georgia state court, if there's no formal incentive being extended by the prosecution to this guy, right? And I think a lot of observers might say, well, maybe there was. Maybe it's just not official. Maybe Woody's had 11 convictions. He had one in 22. He had one in 23. Yet he didn't do any time. Maybe people have been holding Woody's hand and saying, hey, come on, just be nice to us. It doesn't have to be formal.
Yeah.
Because maybe you don't really have anything. Maybe you don't want to offer a guy bond and no time on a charge where he should not get a bond and do time if you plan on using him later for his testimony.
Was he sentenced on those convictions? Because they might have been like, hey, listen, we're going to hold these convictions, the sentencing for these convictions till after you be a nice boy and you do what we want to do. Because right now, I watched him on the stand and it felt like he was almost thumbing his nose at the prosecutors like, yeah, I don't give a fuck about this. And there's a point, and I know you probably saw this, where basically it was like, hey, Mr. Copeland has notified the court that he's not going to testify, and even if he's held in contempt, he's willing to sit in jail. He don't give a fuck how long it is. And I'm like, what? That's crazy.
Well, listen, he said that like he had to, in order for Woody to invoke his Fifth Amendment right and have the court actually accept it, he had to say it like 8 times. And then on the 9th time, he basically said whatever the hell the judge wanted him to say. Right? And then they bring the jury out. He says it. Everybody leaves, mistrial. All right. And then once he invoked the 5th, the judge says, well, you got to go to prison. Right? I'm holding you in contempt. It's Friday. You're going to sit in jail over the weekend. On Monday, you come back. And if you choose to testify, you're out of contempt. If you don't testify, you're still in contempt. And this is where, the pressure and the coercion element comes in. Because that contempt, how long do you think somebody will hold you on contempt if you don't testify in this trial on a Friday? How long do you think you might spend in there?
Sure, you definitely spend the weekend, and if you don't, you might be spending weeks. By the way, and you might not be familiar with these cases, but it reminds me of some other cases. I remember there was an infamous, this is people who are into sports, the Balco case, where I think they were trying to either get, I think it was Barry Bonds, or I think at a point A-Rod, and there was a guy who was a trainer who supposedly was supplying with the steroids, and he was just basically saying, I'm not going to testify. And essentially he got held in contempt and locked up, obviously, until the case ended, but nothing happened to the main people. And that seemed to be like, well, okay, if you get the fall guys to just say, I'm just going to sit in jail to the rest of this trial, but you can't get a conviction without me, that's like a W strategy, right?
It's W strategy, and what you just said is the answer. The answer is you're going to get held in contempt until the case ends. When do you think the YSL case is ending? Exactly.
Do you think that's what they scared them? Because they scared him. Because come Monday, I'm thinking, listen, Woody is a career criminal. He's probably used to shitting in that fucking metal toilet than in his porcelain toilet at home. He knows about them sandwiches in the cafeteria more than he knows about DoorDash. It's no way that he says, I'm not testifying Friday, and 2 days go by and he's like, God damn it, whatever y'all want, I'm willing to cooperate. Because Monday comes around, and you know what happened. He tries to get on the stand.
Well, Monday morning comes around. Woody's supposed to be there at 9:30, so he's in custody. They bring him in. But nobody takes the stand until 11:30. And what happened between 9:30 and 11:30 is the ex parte outside of the
What's
parties.
That?
So the word ex parte in Latin basically just means outside of the presence of the parties. Okay. So in a lawsuit, there's parties. There's the defendants. There's the state. Now, if the defendants have a meeting with the judge without the state, they're having an ex parte meeting. If the judge and the state have a meeting without the defendants, they're having an ex parte meeting outside the presence of one side.
Is that legal?
Well, absolutely. You can have ex parte meetings. Are all of them legal? You can have an ex parte meeting that then leads to a mistrial, what they call reversible error. You should not have had that meeting, Judge. Because you did it, the whole trial is tainted and the verdict, whatever it is, has to be run back. So on Monday morning, after spending the weekend in jail, Woody takes the stand at 11:30. And at 11:30, he takes the stand and he starts testifying. And he's answering the questions, and they take a break. When they come back from the break, Brian Steele takes the podium. And he says, Judge, it's come to my attention that you guys had an ex parte meeting with Woody. And I'd like to discuss some of what I've heard happened in that meeting, because that sounds to me, if it's true, that there was witness tampering that happened. Because I heard a couple things. I heard that Miss Love concurred.
Who's Miss Love?
The prosecutor.
Okay.
Well, I heard that the court told Woody that Woody's going to spend all the time in jail that it takes for this trial to end. And this trial's been going on for 9 months, day 87 of trial, but it's actually taken 9 months of real time. This trial will probably go on for another year. And then the prosecutor kicks in to Woody, hey, you're not just going to sit for this trial. There's other defendants on this indictment who are not being tried as part of this group. And their trials are going to come sometime soon. So even when this trial ends,
good.
You're going to sit. That's good. That's heat.
That's basically saying, hey, you're sitting for the next 3 years. That's like telling him a sentence.
That's sentencing him. That is sentencing him. And doing it outside the presence of the defendants and their counsel. Okay, so Woody hears all that, and he takes the stand, he starts testifying, and then Brian Steele hears that meeting happened, so he gets up on the podium. He's like, Judge, did this happen? If so, if I heard it right, isn't that witness tampering? How could you do that? How could you tell this witness who invoked the fifth multiple times, who you confused the fuck out of about what immunity is? How could you then say that if he doesn't do whatever the prosecution wants, which is testify, that he's going to sit for this long? That without telling us that it's happening, that's coercive. We need to know that all that was said. We need to use it in a cross-examination. Right? We need to know that it happened. It's part of my guy's case.
Okay, so the only question I had for that, because I was listening to Judge, I believe it's Glanville, that's his name. He kept trying to make a point to say, hey, there are ex parte conversations that exist that would include me and the prosecutor. He didn't really say the witness, but I guess it's implied the witness. But every time Steele was like counteracting, he was like, yeah, without the witness. He's like, if the witness is there, we're supposed to be there. I guess that's going to be a big source of disagreement here, because if what Judge Glanville did was legal, I guess nothing's wrong. If what he did was illegal, this case is almost already so tainted, not only by this, so many other things. It's like the appellate court's going to have a great time with this, no matter how it goes, right? Well, I don't think the prosecutor's going to go crazy. But if Thug gets found guilty, and of course, like, it's going to be a cause for mistrial every 20 seconds. So do we know if they could do that? Talk to the witness and the prosecutor alone?
Well, a couple things. One, there should be a complete transcript of everything that was said in that meeting. Now, when Brian Steele took the podium, Brian Steele suggested that at times the court reporter was there, but there may have been things that were said that the court reporter did not catch. And if that's true, then the only people who could tell us what was said are the people who were in that room. And if that's true, then the people in that room are now witnesses to the case, and therefore they can't be the prosecutor or the judge, because they're going to have to testify about what was said in that meeting so that we can have that information to use it for cross-examining Woody and otherwise defending our clients who are being accused of stuff and we're now left out of a critical part of this case. There's case law on it. It's going to get argued forever and ever. I would be interested. What intrigues me in that whole exchange was the judge's sort of obsession with finding out who was the source of the leak, instead of actually addressing head on whether it was proper or not proper.